Welcome to The Explainer. Today, we're going to pull back the curtain on a kind of hidden power in the courtroom, a power that can stop a trial dead in its tracks, long before a jury ever gets to speak. So, when you think of a jury trial, what pops into your head? Probably 12 people, right? Carefully looking at all the evidence. They're the ones who decide what's true. But what if I told you there's this powerful gatekeeper, someone who actually decides what evidence the jury is even allowed to see in the first place? Okay, so to really get this, we've got to start with what most of us believe about our jury's job. Yeah, this is the picture we all have, isn't it? The classic image of justice. The jury hears everyone out, they go through all the papers and photos, and they figure out what really happened. And look, that's definitely true, but it's not the whole story. There's a really important step that happens way before any of that. And this is it. This is the secret veto we're talking about. The judge basically acts like a filter. If they look at all the evidence one side has put forward and just think, you know what, this is really weak, there's just not enough here, they can shut the whole thing down. The case stops, and the jury never even gets to talk about it. So you might be wondering, how does a judge even make that call? Is there some magic formula? How do they decide, okay, this is strong enough for a jury versus, nope, this gets thrown out? Well, it all boils down to a really specific but crucial legal idea. This quote really gets to the heart of it. It shows you the fine line a judge has to walk. See, their job isn't to decide if they personally think the evidence is believable. Nope. Instead, they have to ask a different kind of question, a hypothetical one. If a jury decided to believe all this evidence, could they, logically connect all the dots to come to a conclusion? If that chain of logic has a missing link, if you can't get from A to B legally, then that's it. The case is over. Okay, let's look at a real case to see how this works. Picture this. A passenger gets their thumb totally crushed by a train door. Ouch. Now, there was also tons of evidence that the train company was negligent. The train was dangerously, illegally overcrowded. But here's the problem. The evidence never built that bridge between the overcrowding and the crushed thumb. Nobody could say, yes, the reason his thumb was in the doorframe was because of the crowd. Without that direct link, that one crucial piece of the puzzle, the judge had no choice. They had to say, sorry, there's no case here for the jury to decide. So this isn't just a judge waking up one morning and deciding to end a trial. How does this power actually get used in a real courtroom? Well, it's a formal legal move, and it has a pretty specific name, and it's called a submission of no case to answer. This is a really high-stakes moment in a trial. Here's how it goes down. One side, let's say the prosecution, lays out their entire case. They call all their witnesses, show all their evidence. Then, the defense lawyer can stand up and make this submission. What they're basically saying to the judge is, Your Honor, you've seen everything they've got, and even if you believe every single word of it, it still doesn't legally prove their case. Let's just end this right here, right now. And what's really interesting is how carefully the law protects this whole process. In Australia, for instance, they actually kicked around a few other ideas for shortcuts. One was called the unsafe submission, which would have let a judge toss out a case just because it felt a little weak. Another was the Prasad invitation, where a judge could kind of nudge the jury to stop the trial early. But in the end, they rejected both of those. They decided to stick with the formal no-case submission as the main and really only way to do this. But here's where it gets even more layered. This whole no-case gambit, it doesn't work the same way everywhere. The rules, and maybe more importantly, the risks, are totally different if you're in a civil trial versus a criminal one. Okay, so this is the absolute key difference. In a civil case, like a lawsuit, making a no-case submission is a huge strategic gamble. If you make that argument and the judge says no, they might also say, well, that was your choice. You don't get to present your own evidence now. You lose your turn, basically. But in a criminal case, it's a completely different story. It's essentially a free shot for the defense. The accused's lawyer can try to get the case thrown out, and if the judge says no, it's fine. They can then go on and present their entire defense case. There's literally no penalty for trying. Okay, so we've got this really powerful legal tool, and it works differently depending on the courtroom. But why does any of this matter to us? Why is this one little procedural rule so important for the justice system as a whole? Well, it really all boils down to a fundamental balancing act. On one side of the scale, this power is a really important shield, right? It protects people from the enormous stress and cost of having to defend themselves against a case that's just flimsy or baseless. It saves the court's time and money, and it's supposed to stop juries from making emotional decisions when the actual evidence is weak. But then, on the other side of the scale, you have the fact that it puts a huge amount of power into the hands of just one person, the judge, to decide what a jury of 12 ordinary people is even allowed to consider. And that really is the central question here, isn't it? It makes you think about what we truly want from our justice system. Do we want the clean efficiency of a judge's veto? Or do we want the unfiltered democratic power of a jury? Where you decide to draw that line, well, that says an awful lot about what you think justice should be.